Hello everyone and welcome back to our AIBE preparation series. Today we are going to explore a crucial topic under the Criminal Procedure Code, commonly referred to as the CrPC, and that is arrest procedures. This is not just an important topic for your exam, but also forms the foundation of how criminal justice operates in India. Understanding arrest laws is essential because arrest is one of the first stages in any criminal proceeding and also one of the most sensitive as it directly affects an individual's fundamental rights, particularly their personal liberty under Article 21 of the Constitution. Let's begin with a basic question. What exactly is an arrest? In legal terms, an arrest is the act of apprehending a person and taking them into custody, typically because they are suspected of committing a crime. It is a coercive measure, and it essentially curtails the liberty of the individual, which makes it all the more important that it is conducted according to strict legal procedures. Under the CrPC, the provisions governing arrest start from Section 41 and extend up to Section 60A. These provisions cover everything from who can arrest, how they can arrest, to the safeguards and rights of the person being arrested. Now, arrest can broadly be classified into two categories: arrest with a warrant and arrest without a warrant. The CrPC provides for both depending on the nature of the offense and the urgency of the situation. Let us now look at who can arrest a person under the code. The power of arrest is not only with the police. In fact, three categories of persons have the authority to arrest. First, of course, are police officers who are primarily responsible for investigating crimes and apprehending suspects. Their powers are detailed in sections 41 to 44. Second, magistrates also have the authority to arrest or order an arrest under section 44, particularly when an offense is committed in their presence. And interestingly, under certain circumstances, even a private person can arrest someone, as outlined in section 43, though they must immediately hand over the individual to the police. Now, let's talk about section 41, which governs the power of a police officer to arrest without a warrant. This section is of paramount importance. According to section 41 clause 1, a police officer may arrest a person without a warrant if they have committed a cognizable offense, if there is credible information and reasonable suspicion, or to prevent the person from committing a further offense, tampering with evidence, or threatening witnesses. However, there was a major change in how this section is interpreted post the 2009 and 2010 amendments. The law now mandates that for offences punishable with less than 7 years, arrest should not be automatic. The police officer must be satisfied that such arrest is necessary and must record reasons in writing. If arrest is not necessary, they must record reasons for not arresting as well. This is a big step in protecting individual liberty and preventing unnecessary arrest. Following that, we have section 41A, one of the most progressive introductions in the CrPC. This section talks about issuing a notice of appearance instead of arrest. It is applicable in cases where arrest isn't deemed necessary. The police officer may issue a notice directing the person to appear before them, and if the person complies and cooperates, they shall not be arrested. This provision is intended to reduce the burden on the criminal justice system and avoid arbitrary deprivation of liberty. Let's now turn to magistrates, whose powers to arrest are mentioned in section 44. A magistrate, whether executive or judicial, can arrest or order the arrest of a person who commits an offence in their presence and can also take that person into custody. This reflects the supervisory role that magistrates play over the functioning of the police and the criminal process in general. Now, about the arrest by a private person under section 43. Although rare in practice, this provision allows any private individual to arrest someone committing a non-bailable and cognizable offence in their presence. The condition, however, is that the arrested person must be handed over to the police without unnecessary delay. It serves as a reminder that law enforcement is not exclusively the domain of the state. Citizens also have a role, albeit limited and tightly regulated. Now, let's talk about the procedure of arrest, which is outlined in sections 46 to 60A of the CrPC. Section 46 is a crucial one, as it defines how an arrest is to be made. It states that the police may use reasonable force if the person resists arrest, but it also clearly prohibits the use of deadly force unless the person being arrested is accused of an offence punishable with death or life imprisonment and is trying to escape. This balances the need for police enforcement with the protection of individual rights. Another extremely important aspect is the special provisions for women. Women cannot be arrested after sunset and before sunrise except in exceptional circumstances with prior permission of a magistrate and must be searched only by a female officer. These provisions aim to protect the dignity and safety of women during arrest. Section 50 mandates that the person being arrested must be informed of the grounds of arrest and their right to bail if the offence is bailable. Further, under section 50A, it is the duty of the police officer to inform a friend or relative of the arrested person about the arrest and the place of detention. This was added in response to concerns about custodial abuse and enforced disappearances. Section 57 is another critical safeguard. It mandates that a person arrested without a warrant cannot be detained in police custody for more than 24 hours without being produced before a magistrate. This right ensures judicial oversight and protects the accused from being held indefinitely by the police. Finally, Section 60A, added by way of amendment, reinforces the legality of arrest. It states that no arrest shall be made except in accordance with the provisions of this code. This section makes it very clear that all arrests must be legal, justifiable, and follow due process. Now let's turn to some important case laws which are frequently asked in the AIBE and also help you understand how courts have interpreted these provisions. First, in D.K. Basu vs. State of West Bengal, 1997, the Supreme Court laid down 11 landmark guidelines to be followed during arrest and detention. This case is pivotal in curbing custodial violence and ensuring transparency in the arrest process. It mandates things like preparing an arrest memo, informing relatives, medical examination every 48 hours, and maintaining a register of arrest. In Joginder Kumar vs. State of Uttar Pradesh 1994, the Supreme Court observed that arrest must not be routine. The police must justify the necessity of arrest, even if the law allows it. This judgment forms the basis for Section 41E and the move towards notice-based appearance. Then, in Arnesh Kumar vs. State of Bihar 2014, The court gave specific directions to prevent misuse of arrest powers in offences punishable with imprisonment of up to 7 years, particularly in matrimonial cases. This led to the mandatory application of Section 41A to reduce unnecessary arrest and pre-trial detentions. To sum up, arrest procedures under CrPC have evolved over the years from being police-centric to being citizen-centric, thanks to judicial intervention and legislative reforms. As future advocates and law professionals, you must not only remember the sections like 41, 41A, 50, 57, but also understand their practical implications. Be thorough with landmark cases, and most importantly, understand the spirit of the law, which is to balance law enforcement with individual liberty. This concludes today's lecture on arrest procedures under CrPC. In the next video, we will cover another essential topic, bail and anticipatory bail. If you found this helpful, make sure to subscribe and revise consistently. Until next time, happy studying and all the best for your AIBE exam. Thank you.